So it is now 10 o'clock, and I'd like us to get started if we may. Super. And we'll have everyone, welcome to everyone, and we'll make sure that you all have your mute buttons on. And we will now get started. Good morning, everyone. I'm Linda Spear, and on behalf of the United Church of Christ and the Call to Care ministry team, I would like to welcome all of you today to our 2-hour Zoom presentation on long-term legal considerations when caring for people with dementia. As we are a dementia-friendly faith community, we at Boxborough UCC strive to make an environment that is open, welcoming, and safe for those with dementia and their families and caregivers by providing support and ways to increase their spiritual fulfillment. As a dementia-friendly church, we are pleased to offer yet another program in our ongoing series of programs as they relate to caring for and issues related to those with memory loss and dementia. Today's program is presented by attorney Cathleen Summers. Her program will focus on legal areas such as estate planning, guardianship versus conservatorship, Medicaid, long-term care planning concerns that caregivers may need to consider when caring for those with dementia. So, should you have any questions, feel free to write them down in our chat box. And at the end of today's presentation, we will have a brief Q&A, and she will try to address these questions in an allotted time frame. I've also included in the chat box her contact information, should you want to contact her or any of her colleagues. I am so pleased to introduce Cathleen Summers as today's speaker. Fortunately, many of you already know her, as you're familiar with her through your own professional interactions or from programs that you've attended around the area from her. As a nurse attorney with over 30 years of legal experience, Cathleen concentrates her legal practice on crisis management, Medicaid, long-term care planning, estate planning, and guardianship. She finds herself as the go-to expert on helping clients and their families navigate both the legal and healthcare worlds when a crisis arises. She specializes in crisis management and often supports families who may live out of state or who are unable to provide frequent oversight of a loved one's care. She's sought out by professionals to serve as an advisor on many local hospitals, is a member of several boards in the community, and she currently serves as the president of the Massachusetts chapter of National Academy of Elder Law Attorneys. Welcome, Kathleen, and welcome to all of you for joining us today.
Linda, thank you so very much for inviting me to be here today and to give me this opportunity to speak with you all. And thank you to the UCC for sponsoring this program, such an important program for the community. So very, very excited to be here. I'm going to ask you all to give me a moment while I go ahead and share my screen. I want to be able to bring up today's presentation. Let's see how we go here. Sorry, having a little bit of difficulty. Oh my goodness, I have not had this happen before. I apologize. I am not able to share my screen for some reason. Let's see what happens here. Well, let me go ahead, if I could, while I'm trying to bring this up and just kind of talk with you all. One of the first things that I wanted to bring up as an issue, or just to bring to everyone's attention, was that caregiving and the scope of caregiving, particularly in the US. Pardon me for a moment. I'm going to see if I can get this working properly again. Here we go. Linda, are you able to see my presentation?
Currently, I see a blank screen, but at least I'm seeing something.
Thank you.
I don't know if Ralph is able to. There we go, Kathleen.
All right, my apologies,
That's quite
everyone.
all right. Thank you.
And so now can you see that, Linda, fully?
Ian.
Thank you very much for your patience, everyone. So one of the things I wanted to bring up was this screen that I have here, just talking about caregiving in the US. And these numbers are from 2020, but certainly they've only grown in terms of the number of caregivers. But some really important things to think about in terms of the number of caregivers. We've grown from 18% of the US population is in some kind of a caregiving position to 21% in just a 5-year period of time. And so caregiving continues to be a major focus that I think goes without very much recognition, people who are in the position of caregiving. Personally, I have seen in my own family, I have seen as my own parents and my husband's parents have aged, other loved ones of ours who have aged, people who have stepped forward to be in a caregiving position. And oftentimes I'm seeing that falls on a spouse who may be in their 80s, 90s themselves, caring for their spouse who is dealing with some type of healthcare issue. And dementia has been one of the largest growing issues for us in the US as an overall population. So really important to understand this. Another thing that I think is important when we're looking at this is that the issue of about 39% of caregivers are men and 61% of caregivers are women. That is an enormous discrepancy in terms of the sexes and who ends up having the responsibility as a caregiver. And another important thing to know that many caregivers, about 61% of caregivers in the United States, also have another job. And so caregiving takes a tremendous amount of energy and oftentimes a tremendous toll on the caregiver. And so today, as we're really focusing, I think, on the caregivers who are dealing with a loved one with dementia, it's really important to understand the amount of support I think that they need. We oftentimes remind caregivers that this position really is one that can put their own health at risk. And so trying to make sure that you have as much support, as much of the structure that you can have around you as a caregiver to help you through this position, this and oftentimes a very, very honorable position in the sense that you are honored with the ability to be able to provide love and care for someone who you have had such a close relationship with throughout your life. But you need support as well as you're providing them with ongoing support through this aging process. So really important to really understand and have, I think, some context as to what caregiving really looks like in the United States. So if I could, I want to talk about a couple of things today. Linda really outlined it for us. I'm going to talk about the legal documents because it is important, again, to have some framework in place as a caregiver as you begin to step into these roles. And if we have people who have just been recently diagnosed with dementia who may be listening to this as well, being able to make sure that you're getting in place your legal framework, because it really does become the foundation for which many decisions, which actions can be taken as time goes on and as you continue to progress through either this caregiving role or through your own aging process with dementia. And then I want to talk about what happens if we don't have these legal documents in place, because there is a fallback position. It is not one that we like to see us take if possible, but there is a structure in place and how that works. I also want to talk a little bit today about how things like Medicaid planning and the difference between Medicare and Medicaid, and thinking about how to provide for the cost of services as we age and what that might look like. And then I want to talk a little bit about resources that are there in the community, because as your group itself has shown, you are not alone. And you really need to know what your resources are and be willing to reach out to those resources for help as time goes on, because no one should be doing this alone. So let's really talk about the legal structure. And really, there are really three basic documents, and we usually have four, but I'll talk about the three major ones today that really should be in place, if possible, for someone who has started to deal with a level of dementia. Now, remember, the diagnosis of dementia in and of itself certainly is not something that says someone is not competent to be able to make decisions for themselves. And we need to recognize that. Dementia, again, the diagnosis of dementia itself doesn't mean that someone isn't able to understand and participate in decision-making for themselves. But as we begin to see someone progress through this type of disease process, we know that cognition does begin to decline. And making sure that we have legal documents and individuals identified who can step in to be able to make decisions based on what the person would want to have done in place can be critical. So the first one is called a healthcare proxy. This is really a unique document to Massachusetts. Other states have healthcare directives. But in Massachusetts, we have a law that says we're going to appoint someone to step into our shoes to make healthcare decisions for us in the event we're unable to make healthcare decisions for ourselves. So a couple of important things to remember about a healthcare proxy. First of all, it's just a document that provides authority to somebody else. It doesn't tell us what's critical to you. So it doesn't say, I would want to be resuscitated. I don't want to be resuscitated. I want a feeding tube, etc. We choose a person, and that proxy, should we be unable to make decisions for ourselves in the healthcare arena, will step into our shoes to make those decisions for us. So it is critical to make sure that you have conversations, whether you are the individual who is experiencing dementia or you are the caregiver. You want to try to find out what's important here. If a healthcare crisis occurred, particularly around things like end-of-life decision-making, what is the framework for healthcare decisions? Because it is the person who's going to make decisions, not some paper that's going to dictate how things should be managed. So having those critical conversations around healthcare, not always easy conversations to have, but absolutely critical ones to have. And we talk a lot in the office about, how to have these conversations and when to have these conversations. And the truth is that they're ongoing conversations, and they're ones that you want to check back in with the person who you might be acting as the proxy for, should it be necessary, to make sure that you're truly understanding what they would want should you have to step into that position. So the proxy is just a document that names another individual. It gives broad range of authority to that person to make decisions around healthcare decision-making. And you need to make sure you're getting either the framework from the person for whom you're acting as the proxy, or you're giving the person you've chosen to be your proxy that framework. Have those conversations. A couple of things about healthcare proxies to know: they can be revoked at any time, just like all of the documents I'm going to be talking about today. They are changeable as long as someone has the level of competency necessary to be able to make those kinds of changes. The other thing to know about a healthcare proxy is that it only becomes effective when the individual becomes incompetent or incapacitated. So it must be activated by some type of medical documentation saying that it is no longer, the person is no longer able to make decisions for themselves. So the document requires some form of activation by having medical personnel state that this individual can no longer make decisions for themselves. So the other arena is the financial arena. And in this place, this is where we have a document known as a durable power of attorney. This is a very broad-based document, very powerful. It contains a tremendously broad range of authority. And this is a document in which you name someone who will step into your shoes to manage all decision-making for you but healthcare, should you become incompetent or incapacitated. So this is a document that we oftentimes think about in terms of the financial world. It allows an individual to be able to handle your bank accounts, to be able to make decisions about your retirement plans, to be able to make investment decisions, etc. They can handle your real estate. They can make decisions in terms of living arrangements. So a tremendously broad range of decision-making is part of this document. Now, a couple of questions that people often ask is, first of all, why would someone ever put this kind of document in place? If it gives such a broad range of authority to make decisions for me, why would I ever consider doing that? Well, like the healthcare proxy, and I'm going to talk about this in a few moments, but like the healthcare proxy, if we don't have a decision maker appointed to handle your financial life, to be able to handle these kinds of decisions for you, end up having to go to a court, and we have to get a guardian and or conservator appointed. And you'll hear in a few moments why that is just not the route you want to go if possible. So putting a power of attorney in place ahead of time while you're competent to be able to make the decisions about who would step into your shoes makes it so that, first of all, the person you want to be in that position has been identified. And so you're still kind of in control of things, even if you lose your competency to be able to make decisions. And it also makes sure that you have been clear about what your wishes are and what's important to you with respect to handling your finances and handling your personal life. It gives you an opportunity to be able to speak with that person. Now, there are two types of powers of attorney to be aware of. There's one that becomes effective the moment you sign it. And so oftentimes we see this with spouses, or we see this when a parent may be giving this type of authority to a child, a trusted child, that they may want them to be able to step in and start to handle things like their finances, even though the person continues to be competent and capable of doing it themselves. But it just has become too much of a burden, too much of a hassle to be going to the bank and making these kinds of decisions. So the power of attorney that becomes effective immediately doesn't require the principal, the person who has created the document, to be determined incompetent or incapacitated. Now, the benefit of that is there's no hurdle in the way of the person that you've named as your agent or your attorney in fact under the power of attorney to act. But of course, the downside is that this person now has very broad ability to be able to go ahead and make decisions on your behalf. So the other type of power of attorney is called a springing power of attorney. It first requires that you be declared incompetent or incapacitated before the document becomes effective. So of course, the benefit there is that nobody's running around acting on your behalf unless there is a reason, but it also can be a very large hurdle. Sometimes to get healthcare providers to be willing to document the competency of an individual can be difficult, and it can take time, and it can cause a delay for the agent under the power of attorney to be able to start acting. So you have to think about who you're asking to be in this position. First of all, it should be someone who you have utmost confidence in and belief that they will do what's best for you and based on what you would want to have done. And then you need to think about that level of, are you comfortable in giving that kind of authority right away? Or do you want to have this kind of little bit of a hurdle that they have to jump over first before they're able to act in this capacity? So powers of attorney, very broad documents, very powerful documents that allow for the management of particularly your financial life, but ones that really allow you to be able to determine who you want to have go into this position. And as the caregiver, having this authority in place, make sure that you're allowed to handle the decision-making for your loved one, for the person who you are providing care for, and be able to make the decisions based on what is best for them and what they would want should they be, if they were able to make those decisions for themselves. Oftentimes I have couples who may have their whole financial world for many, many years, couples married, 40, 50, 60 years, that have always had joint accounts and joint ownership on things. And they'll say to me, well, why do I need a power of attorney? Well, the truth is for things like your bank accounts, if you jointly own savings accounts, investment accounts, non-retirement accounts, you are correct. As the joint owner, you have the ability to be able to manage those assets completely without having any kind of power of attorney in place. But there are certain assets that you cannot manage without having the authority to do so. One is your real estate. So if you jointly own your home together and one of you becomes incompetent or incapacitated, the other is not able to do things like sell the home, to be able to handle any mortgage that might be on the home, or to be able to obtain things like lines of credit without the involvement of the other. And so another area that you can't manage is retirement plans or pension plans. You have no authority to be able to manage that for your spouse. And so having this document in place, should one of you become incompetent or incapacitated, makes it so that the named agent is able to handle things. So very powerful document, but critical to consider having in place ahead of time. I get a lot of questions about what's known as a MOLST form when we're talking about healthcare decision-making. And a MOLST form stands for Medical Orders for Life-Sustaining Treatment. You're going to hear that there's some movement here in Massachusetts because we always seem to be different than everyone else in the country, but trying to change this to what's called a POLST form, Physician's Order for Life-Sustaining Treatment, but it's really the same thing. So whether you hear about a MOLST form or a POLST form, it is the same thing. Now, this is something that isn't done with an attorney. This is done with your healthcare provider. And I like to think about it like a prescription. It is something that can follow you no matter what setting you're in, whether you're at home, in an assisted living, in some kind of a supportive living environment, in a hospital, in a nursing home. The MOLST is able to follow you no matter where you are. And it actually does talk about specifics. Unlike the healthcare proxy, the MOLST form is actually going to outline, do you want to be resuscitated? Do you not want to be resuscitated? Things like feeding tubes, things like rehospitalization, all kinds of different questions about what you might want, particularly related to end-of-life decision-making. And this is a document, again, the reason why it follows you from one place to another is that what we had found is that when an individual was hospitalized, they often went through these kinds of questions with the staff there. But then when they went to the next step, let's say they went to a nursing home, had broken a bone, went to the hospital, and then went to a nursing home for some kind of rehab services. At the rehab, they ended up having all these questions asked again and having some kind of documentation then. And then maybe the person went home. And when they were at home, oftentimes what happens when we're at home is that we don't end up with any kind of specific order that can be followed by first responders, let's say, should something happen. So let me give you an example. Someone has an end-of-life disease, let's say even a form of aggressive cancer. They have been in the hospital. A MOLST form is put in place. They then go to a rehab setting for some rehab services and then home. When they get home, and let's say this individual has gone home for end of life. Well, oftentimes family, the immediate response when someone ends up having a medical crisis at home is to call 911. Well, when 911 is called, and the emergency responders come in, they will do whatever they need to, and often, bring the person to the hospital. That's their job. But when there's a MOLST in place, a MOLST order in place, they now can follow that medical order. And if it says do not resuscitate, if it says do not hospitalize, they're able to follow that without issue or concern. So that's what the MOLST is for. It's to try to keep continuity in terms of what your wishes are in place, no matter what setting you're in. Now, MOLSTs are oftentimes done only for certain groups of people. So if you're an otherwise healthy individual, most likely your physician's not going to sign a MOLST form with you that says do not resuscitate. Because of course, if something happens, then resuscitation would be the first response if it was necessary. So we often find that MOLST forms are done with people who are at certain stages in a disease process. If you have something like an end stage disease that is, going to lead to end of life, this is where a physician will talk with you about a MOLST form. They also will speak with people of, and always say this with a little caveat, of a certain age, and that's very subjective. Like, what is the age that you would do this with someone? Is it 85? Is it 90? Is it 95? This is a conversation with your physician in terms of what your wishes are and when he or she, would agree to put a MOLST form in place for you. So certainly bring it up in terms of a conversation with your healthcare provider, but know that they may not do it at this point, depending on what your personal situation is. So one last medical or healthcare related document that we like to see in place is what's known as a HIPAA authorization or release form. HIPAA is the privacy law that went into play in the 1996, but really went into effect in the early 2000s. This is where your healthcare providers will not share personal information with you, except with those individuals who you have identified. So certainly the people who you've named as your healthcare proxies, you want them to be able to speak with your healthcare provider so that they can get information without any barriers. But you may have a larger group of people. So for instance, you are an individual who has a spouse. You want your spouse, let's say, to have the ability to make decisions for you, but maybe you want your children to be part of a conversation that may happen with the physician so that everybody's on the same page. So that's the HIPAA authorization and release form. It allows you to identify the people you want to be part of the conversation, but they don't necessarily have to be decision makers. And as a caregiver, you definitely want to make sure that you have the authority to be able to speak with the healthcare professionals about what's happening with the one you're providing care for, so that you understand what's happening with them in real time. So let's talk about what happens when we don't have any of these documents in place. And this is really the conversation about guardianship and conservatorship. And you're going to hear why avoiding this as much as possible is really the way to go. You really, if you can, want to see if you can get those documents in place ahead of time so that you don't end up being in a position in which there isn't an identified decision maker. So let's talk about guardianship first. So guardianship is the process, and these are legal proceedings in which we get someone named to be the decision maker for someone about everything but their finances. So this is kind of akin to a healthcare proxy. If we don't have a healthcare proxy in place, then we need to get a guardian appointed. We need to get somebody in place to be able to make healthcare decisions. Again, in Massachusetts, we don't have what's called a next of kin law. So by law, the spouse of someone isn't an automatic decision maker. The parent of someone isn't an automatic decision maker unless the child is under the age of 18. A child of an adult is not their automatic decision maker. We need to have somebody who has been identified legally, either through one of the documents that I just talked about or through a guardianship proceeding. And so a guardian, they have specific responsibilities. They are, when someone has been declared incompetent, and the declaration of incompetency is really a medical determination. The courts just adjudicate that. They just say, yes, this is actually true. This person is no longer competent. But competency is always based on a medical determination. So when we begin a guardianship proceeding, the first thing that we need to obtain is documentation that this person who we are seeking guardianship over, we call them the protected person, is no longer competent to be able to make decisions for themselves, and they need a decision maker put in place. A couple of things about the court proceeding just to know about. The presumption is always that someone is competent until we prove that they are not competent. Once they're proven incompetent, then it switches. And if the person regains their competency, they then have to prove that they are competent again. But initially, it is always presumed that we are competent to make our own decisions. So the role of the guardian is to step in to make decisions about things like self-care, health of the individual, and safety of the individual. And one of the things, we went through a pretty major change here in Massachusetts back in 2012 when we introduced what was called the Massachusetts Uniform Probate Code. We really made strong efforts to continue to recognize that someone, even when they're not competent, may be able to still make decisions for themselves in certain areas of their life. And so when we go through a guardianship proceeding, we're always looking to say, what areas can this person continue to make decisions in, even if they're declared incompetent for other things? Like maybe the big decisions about truly understanding the risks and benefits of different healthcare options, they're not able to grasp, but being able to control who they see, who they interact with, their friends, being able to even, make smaller decisions about their life. We want to maintain as much independence for the person as possible. So we're always trying to support someone's ability to be self-directed in their decision-making. And this is something as a caregiver that we always want to try to remember, is that even though someone may be suffering from dementia, even though their competency really may be compromised, we want to try to find where can we continue to honor their ability to make independent decisions for themselves. And that's a real balancing act. My own mother-in-law had suffered from dementia for the last 10 years of her life. My father-in-law was her primary caregiver, and they had been together 68 years when she passed. I laugh a little bit because I remember many of their interactions. And at one point, my mother-in-law just was not eating. She was never a good eater. And she never liked to drink water. And toward the end of her life, of course, dehydration became more and more of an issue, and she was losing weight. And my father-in-law, with all the love in his heart, continually tried to get her to drink and to try to eat, to the point where we used to joke, she would say to him, "You're bullying me." And it's a balancing act between trying to encourage the individual to do what we believe is correct for them. And we know from a medical standpoint, let's say, would help them to be drinking, to keeping themselves hydrated, with also continuing to respect, she was never someone who liked to drink water. So what other options might we be able to bring in here? What other ways might be able to be used? He used to, we used to tell him, give her some small jobs. She lost the ability really to be able to do any kind of cooking at all, but to give her a small job of maybe being able to prepare the peas, take a lot of pea pods and be able to have those prepared. Some kind of small task kept her involved in the whole process while not giving her the responsibility of cooking something on the stove. And so it really is, as caregivers, one of the things that we constantly need to remind ourselves is, where can we continue to support the independence of this person where possible, support really their dignity in terms of their involvement and their ability to make decisions on even small things related to their everyday life. So guardianship is a legal proceeding. It is necessary when we don't have someone who has been named to be able to make things like healthcare decisions for someone, and it does require a court proceeding. Now, a couple of things to remember, and just a quick definition of when someone does meet the requirements of incapacitation. And again, if we're going to court, we have to make sure that they are determined incapacitated from a medical standpoint and then adjudicated legally. But typically it's where they can't make decisions, they cannot it's of a procedure, or they can't understand how to maintain safety for themselves, handling personal care issues, and all of these things go into an evaluation as to whether someone is competent or not. And I always tell people, if there's a question about competency, and I know even when someone comes into the office and we're talking about, let's say, possibly doing these legal documents for someone, we always have to make sure that they are competent to be able to do it. And if there's a question, we always get a medical determination. So always start with that medical determination about whether competency is in place or not. Few things about guardianship to know: that once we're in the court system, guardianships require ongoing court authority. And so many of the decisions that a guardian makes have to be brought back to a court in order to be ratified. So we're finding we're always going back into court because a guardian is able to make a wide range of decisions for the person who they are overseeing, but there are limitations on what they're able to approve. And one of the big ones is what we call this Rogers authority. And it oftentimes comes into play with someone who is dealing with dementia. This is the authority to be able to authorize the use of antipsychotic medications. And we see antipsychotic medications used with dementia patients, things like sundowners, and helping to address sundowning issues is a big one. But there are other things that can come with forms of dementia. And I'm sure, as all of you know, dementia is a broad term that covers a variety of different medical issues. And different medical issues come with certain kind of issues, like sometimes psychosis. So the use of an antipsychotic medication is considered to be a form of chemical restraint. It's like using, let's say, a physical restraint on someone to keep them sitting in a chair. That is something that we don't allow without a very high level of scrutiny. So the use of something like an antipsychotic medication is a way of restraining somebody. And we need to make sure that we have a higher level of review on that. So if a loved one is under guardianship and the use of antipsychotic medications is going to be necessary, we have to get additional authority from the courts. And the courts oversee this every year. They have a review process every year to make sure that the use of these antipsychotics are appropriate. Now, one thing to remember when we have a healthcare proxy in place, particularly if you have a healthcare proxy that has the explicit authority to allow that proxy to make decisions about antipsychotic medications, then we don't have to involve a court, because you've already taken care of this privately. You've already given somebody, or as the caregiver, you've been given the authority already to make these kinds of decisions. So this is only in the event that we don't have the legal documentation in place and we need to turn to the courts to get a guardian appointed with this additional authority. There's another additional authority that is necessary to go back to a court for, and that's the ability to be able to admit someone to a skilled nursing facility, particularly for long-term care. So again, if we have a healthcare proxy in place, then this is not an issue. The proxy has the authority already to make these kinds of decisions. But if there is no healthcare proxy in place, and we have to turn to the courts and get a guardian in place, and the person needs to go to a long-term care facility, we have to get extra authority to do that. And as you can imagine, guardianships and all of these extra court trips to get the additional authorities cost a lot of money. It's about $3,500 to $5,500 just to get a guardian in place. And then these annual costs and the annual reporting requirements that are necessary for the court really can add up. And so avoiding guardianship when possible is absolutely the way to go. So let me talk about conservatorship as well. So it used to be in Massachusetts before 2012 that when someone was appointed as a guardian for someone, they had the authority not only to make decisions about the person, but they also had the ability to manage their financial life. 2012, so that we had guardians who could make decisions about the person and conservators who can make decisions about the finances of the person. So someone can be under a guardianship, but not a conservatorship, or vice versa. Someone can't, oftentimes we see it more this way, where someone has really not been able to manage their own financial life, but they can still make decisions about their own personal being. So conservatorship is when we have someone who needs to have someone appointed to manage their financial world. And we see this usually when there isn't a durable power of attorney in place. So remember, when there's a durable power of attorney, they have the authority to manage someone's financial world. But without that, then we have to get the conservator appointed. Again, it's based on someone's competency. We begin this always with a medical determination that the person is no longer competent to manage these affairs. And then it's a court proceeding to get someone appointed to be able to manage this for them. Oftentimes when I will find myself in the position where a court has asked me to step in for someone to be their conservator and or their guardian and to be managing things for them. Now, the interesting thing when you end up with someone like myself in these positions is, remember, I've never met this person before. This is something where a court is asking me to step forward, and I am now acting as a professional to make these decisions. And the hard part oftentimes is I don't know who this person is. And usually if someone like myself is stepping forward, they don't have a close-knit group of people around them who can help me to really understand who this person is and what's important to them and the framework for making decisions. And so I'm oftentimes making decisions in a much more kind of clinical way in what I think is what's best for this person, as opposed to really understanding who this person is and being able to step into their shoes and make decisions based on their perspective of what would be important or not. So getting the guardian, getting the power of attorney, getting the healthcare proxy, having the person, if you're the one who is choosing someone of your choice, and if you're the individual who's been asked to be in this position, understanding what your loved one, what the person you'll be acting for, understanding what's important to them is critical so that you can do this job well. But with a conservator, it's a court-appointed person. They're managing the finances. They're making decisions about what should happen with this individual's financial life. Again, there's ongoing court oversight onto everything. There's annual reporting required to the court, and it's extremely expensive if you have to go down this road. So a couple of things in terms, again, of the responsibilities of a conservator. They manage the income of the person. They manage all of their assets. They make decisions about whether to sell a house, how to handle financial investments, retirement plans, everything. They pay the bills. They do, again, have an ongoing responsibility to report to the courts about what's happening with the financial life of this person. They have to give an accounting every year, and they have to show what they're doing with the person's money. So why don't we switch gears a little bit now and talk about long-term care planning. So we've talked about the documents that we want to have in place if possible, and what happens if we don't have those documents in place. But let's talk a little bit about long-term care planning. And this is really what a lot of people know as Medicaid or Mass Health. We call it Mass Health here in Massachusetts. So let me start with just a quick overview, and this is a very general overview of the differences between Medicare and Medicaid, because oftentimes I find clients get these two terms confused. Medicare is the federally run system. It's based on age or disability, and most of us over the age of 65 will receive Medicare. I oftentimes think of Medicare as being a sick insurance, and the reason I call it that is because the Medicare system is really there as a safety net. It covers more of emergent situations. This is basic Medicare. It covers hospitalizations up to a point. It covers visits to your physician for illness. So it's not your traditional, what we think of as our employer plans, where you can go see your doctor and have a wellness visit. This is basic Medicare. Now you can buy a supplemental Medicare plan. You can buy into one of the enhanced, more like your employer plans, where you can go see your doctor for a wellness visit. And it covers more of the things that we consider when we think about traditional health care through an employer. But our Medicare system itself is really a fallback. It is there to cover illness and more catastrophic events. And as I said, it doesn't cover everything. As I'm sure those of you who are on Medicare know, standard Medicare doesn't cover everything. And you can purchase some of these enhanced plans if you want to. Now, Medicaid is a state-run program. It is federal in the sense that there are federal regulations that set up Medicaid, but each state administers it separately. And that's why the rules on Medicaid differ from state to state. So if someone is coming from another area or you are considering moving to another state, the rules around Medicaid will be different. And Medicaid tends to be based on your asset holdings and/or income, and it depends on the program. So a lot of times people think about Medicaid, particularly for younger people who may be below a certain income level. But when we are talking about older individuals, we're usually talking about two different programs. One is the community-based Medicaid program, and the other is the long-term care-based Medicaid program. Community-based is when someone is living in the community and wanting to get services that are going to be paid for by the state at home. Long-term care is for those who need nursing home level care. So I'm going to talk a little bit about both of these programs for you. So community-based, we often call it also what we call the Frail Elder Waiver Program here in Massachusetts, although that is only one of the community-based programs. There are several. And this is to become eligible for this program under the Frail Elder Waiver Program. As an individual person, you need to have nursing home level services, but you want those services provided at home. And you have to meet both asset limitations and income limitations. And I'll talk about what those are. Bless you. When we're talking about long-term care, this is nursing home-based care, it's typically just assets that we're looking at. Your income level normally does not become an issue. And so I'm going to go through what those levels are, and you're going to see they're quite low, but I'm going to talk a little bit about some of the planning options that we can use for someone. That's just a quick difference between Medicare, which is the federally run system, and Medicaid, which is administered by the states. So one of the first things you need to know about Medicare is that in order to have your nursing home care paid for, the first thing under Medicare is that they'll only pay for rehab services. And in order to be able to get rehab services under Medicare, you have to have had at least 3 nights stay in a hospital. Now, this becomes an issue oftentimes because we'll see that someone goes to a hospital, and even if someone ends up being admitted from the emergency room to a floor, the hospital may not categorize them as an inpatient. They may keep them on what we call observation status. So if you are dealing with a loved one who has been admitted to a hospital for services, you always want to double check. What has the admission status been? And the admission status must be at least 3 nights stay as an inpatient in hospital before Medicare will pay for a subsequent stay at a skilled nursing facility for rehab. And remember, if they do go to a skilled nursing facility after the hospital, it must be for rehab services for Medicare to cover it. And Medicare will pay up to the first 100 days of rehab services. Days 1 through 20 are paid fully, and days 21 through 100 are subject to a copay. Typically, that's 20%. Once the 100 days is over, Medicare will no longer pay. And most people in a rehab stay don't get the full 100 days. They may get somewhere between about 3 to 5 weeks at most. So that's just important to know about Medicare. They don't pay for long-term care services in a nursing home. They only pay for rehab. And there are limitations around eligibility that you have to make sure are met. So if a loved one goes into a hospital and you find that they have not categorized them as an inpatient, you need to start fighting and advocating for your loved one at that point as to why this should be an inpatient stay and not just an observation stay if they're going to be going to rehab afterward. When someone enters from so if someone is going from the hospital to a nursing home and it's not rehab services, it's long-term care services, or someone has gotten through their 100-day benefit and it's determined that they can't go home, that they need to stay in the long-term care facility for services, or you're bringing them in from home. So someone is living at home and you really no longer can safely provide care for them at home, and they really need to transition to a long-term care facility. We're talking about a very different situation with respect to payment. Now Medicare will not pay. And now you're either faced with private paying. If they have long-term care insurance, then certainly that can be very helpful. Or you're looking to get this person on Medicaid or Mass Health. And I think most people know nursing home care is extremely expensive. It costs about $13,000 to $15,000 a month right now in Massachusetts on average. So that's a very high cost for long-term care. And I do want to make a quick comment about long-term care. You know, I used to say 2 things. I used to say, first of all, no one would want to go to a long-term care facility. That's not true. There are circumstances in which it is appropriate for someone to go to long-term. For instance, you no longer can provide care for them at home. It's not safe either for the caregiver or for the individual who they're providing care for. And I have had individuals who say to me, I am more comfortable, I feel more safe, I feel more secure in a long-term care facility than I did living on my own, let's say. And so I used to say no one would ever want to go, but the truth is that's not true. It is an individual thing for each person. And the other thing that I have heard is caregivers who say, I made the promise that I would never put my loved one in a long-term care facility. And while that is an incredibly honorable thing to promise, it is not something we always can do. And again, you have to think about the caregiver's well-being, how they're doing, can they continue to manage this situation? Because sometimes the health of the individual has become such that we cannot provide them with the right level of care at home, and their safety and their needs really require something like a long-term care facility. So I just want to put that out there because I know that's one of the big things for many of us, is that nursing home care is the last thing we want to consider. And I just say that sometimes it's something we do have to consider, and we've got to look at it case by case. But let's talk about how we're going to pay for it. So in order to qualify for long-term care assistance through Medicaid, and I'm going to talk about both in a hospital, in a nursing home setting and at home, and how you can get services, there are rules around eligibility. For someone who needs to go into a long-term care facility, again, remember we look at assets mostly, and the individual themselves can have no more than $2,000 in assets in his or her own name. So if the individual owns a home, let's say, one of the fallacies are, well, the state's going to make me sell the home. Well, that's not true. The state can't make someone do anything. You can own a home and still go into a nursing home, and as long as you only have $2,000 in assets other than the home, you can keep the home and go into a nursing home and get services paid for by the state. The state will lien your home, but sometimes there's a reason why we want to let that happen. When the state pays for care, they pay at a rate of about $8,500 a month, where when you private pay for the care, you could be paying between $13,000 and $15,000 a month. So sometimes, even though someone may own a home, we might, but if they need nursing home level care in a facility, we might say, let's still go ahead and get them on Medicaid, even though we know they will lien the house. Because if we sold the house and made it cash, we'd have to spend it down at that $13,000 to $15,000 a month rate. But if we keep the house and we have the person go into a nursing home, the state will put a lien on the home, but it's only at $8,500 a month. And that value is reduced by whatever the person's income is. So let's say the person's receiving $2,000 in income from Social Security. They're actually only having that lien at $6,500 a month. So you can see we might be able to save some of the value of that property for things like beneficiaries. That's a lot to kind of get your head around, but it's one of the things that we look at when we're doing planning. But the important thing to remember is that for someone to be able to get Medicaid benefits, they can only have $2,000 in assets. Now, when we have a married couple and one of them needs nursing home level care, there's actually a lot of things that we can do, even in the 11th hour, to protect assets for the healthier of the two of you. So one of the things that the state says is that if you're going to go on state benefit, you can't give away your assets. They don't want you taking your extra money and giving it away to children or to someone else and then saying, wait a minute, I want state assistance. Well, if you gave away your assets anytime during 5-year period before you apply for assistance, the state's going to say, hold up, you gave away your assets, we're not going to pay for your care. Now, they can't make that person give the assets back. They just are going to deny you care. But when we have a married couple, we can transfer assets between that married couple without having that 5-year penalty come into play. So let me give you an example. We have a married couple. One of you needs nursing home level care. You have about $200,000 in assets between the two of you, and you own a home. We can take and transfer the home from both of you to the healthier of the two of you. So we get it out of the name of the sick spouse. We also take $200,000 and transfer it from the sick spouse right over to the healthy spouse and not have that 5-year penalty period come into play. So we make it so that the ill spouse only has $2,000 in assets in his or her name, and we give everything else to the healthy spouse. Now, there are limitations on what the healthy spouse can have. They can own their home, and as long as it's less than, I believe it's $908,000 in equity value right now, they can keep it without any problem. They also can keep all of the other assets up to approximately $137,000 in value. So in the example I just gave, there's about $70,000 that are over the amount you're allowed to have. So there's ways that we can spend that money. One is there's certain things the state allow you to pay for. Certainly anything you need, the state allows you to pay for. So if you need a new car, you need clothing, you need medical care, anything, the state will allow you to pay for that as long as it's for you or your spouse. If you want to prepay your funeral expense, you can do that. So prepayment of funerals are allowed. If you still have money that's over the $137,000, we utilize a specific type of Medicaid annuity product. This is a financial product that is only to be used when we're looking to do this kind of planning. And it allows us to take that money that's over the value. So this was about the $70,000 I just talked about that the community spouse has, and buy the Medicaid annuity that returns all of the money to the spouse over a period of time and allows us to get the ill spouse on benefit right away. So I think there's a lot of numbers I've thrown at you, a lot of rules. I think the important thing to take from this is that when we have a married couple and one needs to have health care provided at a long-term care facility, there's a lot we can do to protect the assets, even if we've waited to the last moment. Okay, so we can do a lot to protect the assets for the healthy spouse. We also call that person the community spouse. Now, of course, if the community spouse needs benefits in the future, we don't have the same planning options. So if we just have an individual who needs to go on services, we're more limited in terms of what we can do. There are certain things that we're able to do, like prepaying funeral expenses. We can utilize a couple of things. One's called a pooled trust. One is for the ill spouse, an annuity. But these are all things that you want to talk about with a professional to see what's appropriate for your particular circumstance. Now, the other program that people oftentimes don't realize is that Medicaid will also pay for community-based services. And as I had mentioned before, we often call this the Frail Elder Waiver Program, but there are other programs that are allowed in the community. So before I get into that, Linda, I do know that you had wanted to talk about maybe a quick chance to do a stretch and be able to make sure everybody has a quick breather before I kind of wrap up this last part of it.
That would be great. Thank you, Kathleen. Let's just take 5 minutes and we'll return at 11:10. Just take a stretch and get something to drink. We'll see you back in 5. Okay, everybody, we're back. Kathleen, are you back?
I am. Thank you, Linda.
Super.
Wonderful. So let me go ahead and explain how the community program works. For this, we're actually looking at both income limits and asset limits for the applicant. Again, the asset limit is no more than $2,000. Then the income limit at this point is approximately $2,300 a month. Now, if you have more, and this is just for the applicant themselves. So if there's a married couple, the spouse's income is not part of that calculation. It's just the applicant's income that we're looking at. And if it's more than the approximate $2,300 a month, there may be some things that we can do. So we look at the different income sources to see if there's anything we can change. Unfortunately, you can't give back your Social Security even if you wanted to. And there are some limitations about what we can do, but we do look first at the income sources. And then if you're over the income limits, you may still qualify for the community program with what's called a spend down or a deductible that ends up being calculated. But the benefits of the programs for home is, again, the state is trying to find ways to help keep people at home so that they can get necessary services at home. So the state will first of all say, do you qualify medically? So do you need a nursing home level of care, but are looking to get this at home? And then do you meet the financial criteria? And if someone has more than the $2,000 in assets, we are able, again, there are some spend down things that we can do. But the biggest difference between the community-based program and the long-term care program is that right now, the community-based program does not apply the 5-year look back. So someone literally could take all of their assets, give them away today, and apply for the program tomorrow and qualify. Now, if they need nursing homes sometime within 5 years, then the 5-year look back will come into play, but it doesn't come into play for the community-based programs at this point. Now, the community-based programs sound wonderful, and there's certainly an option that you're going to want to consider if you are in a caregiving position and what you really need is just some extra help at home to be able to make sure you can keep your loved one at home for a longer period of time. The community-based programs can be helpful. Now, they don't cover 24/7. Matter of fact, most programs can't cover more than somewhere between about 20 and 30 hours a week, and that's if you're lucky. And I'll explain a little bit about that. Each of the community-based programs are administered by what's known as the ASAP in your area. Boxborough is serviced by Minuteman Senior Services, as is, I believe, about 26 of our area. Minuteman Senior Services out of Bedford, Massachusetts. And their job, they're a quasi-state organization. Their job is to take care of disabled and seniors in their communities by providing them with extra levels of services, everything from home care to care management services, nursing services. They have a wide range. They do Meals on Wheels, a very wide range of services. So each ASAP, and there are multiple ASAPs throughout the state that have different catchment areas, each ASAP gets a certain level of money from the state to run their community-based programs. So part of what happens is it is dependent on how much money that ASAP received, how many people they're servicing under the program, and what the availability is of caregivers. That's become one of our biggest issues for these community-based programs is we don't have enough qualified caregivers to provide services. So again, it's not a program that will usually cover 24/7, although in rare cases we are able to do that. Usually we are looking for a situation in which someone has other caregiving services, a spouse or child or another loved one who is ready and available to be able to provide care, but we're looking to supplement it to be able to give that caregiver a little bit of a break, to help give them, some assistance, that kind of thing, to be able to keep the individual at home for as long as possible. So knowing about these different programs, there's a couple of other great programs. We have PACE, which is PACE. It is actually a program, unfortunately, in our immediate area, which is still not available, but it's starting to come down toward this area. We just did a great in-program and in-service program that people are more than welcome to go on to our website to take a look at the PACE presentation. This is an all-inclusive program, keeping somebody at home, but it includes things like daycare services where the individual can also receive all of their medically related services, making sure that, their plan of care is kept up, that they're getting things like their flu shots if they need medication. All of that is centralized under the PACE program, under one program, helping to keep somebody in the community for as long as possible. So there are some different programs out there. My recommendation, and I'm going to talk very soon about resources, is find out about what resources are out there to help you as the individual who may be experiencing dementia, or if you're in a caregiving situation, find out what services are available to help support you in providing care for your loved one. And there are programs that are covered by the state that do provide services, or at least some level of service, while the person is still living in the community. So critical to talk about what's out there and how can you find some help, and what might the state be able to help to pay for, and how can you become eligible for that? Because the community-based programs do offer us a little bit more flexibility, particularly where they don't have that 5-year look back. That gives us a lot more options in terms of planning for somebody. So let's talk about resources. And I always say to people, find out about your resources as soon as you can. So if you have a loved one who's been diagnosed with something like dementia, or you yourself have, begin to take a look at what the resources are out there. We talked about things, like the ASAPs. Again, Minuteman Senior Services is ours out of Bedford for our particular catchment area. Your local councils on aging, Boxborough Council on Aging, Acton Council on Aging, all have incredible resources and listings of services, of support groups, of individuals who can help to provide services to help keep somebody and support them at home. Things like transportation, particularly where we live, there are, as we are more rural. It begins to be isolation issues for someone, transportation, doctor's appointments. These are oftentimes the biggest stumbling blocks for us in terms of being able to stay at home. The UCC, I'm sure you guys have a robust resource program to try to help, as well as you have your own part, I'm sorry, I'm not going to be able to say the word, and I don't know why. Your parishioners, excuse me, I almost was saying petitioners, but your parishioners, who are incredibly supportive and help to be able to keep people and have programs to be able to help make sure that someone's not isolated and alone at home, and help those kinds of services. Reach out to your medical professionals. They also have listings of services that may be available dependent on your particular situation, and helping to get you to the right people. Groups like the Alzheimer's Association, other support groups, caregiver support groups. Reach out and find out what's out there. You want to know about your resources as soon as you are able, because even if you don't need them. So I always say to people, like with Minuteman Senior Services, just find out what they offer. You may not need the services now, you may never need the services, but knowing what's out there before you hit a crisis point is critical. If you're thinking about if your home situation is not conducive to being able to age in place, meaning that you don't have easy access to a bedroom and a bathroom and your kitchen and your laundry room all on one floor. Let's say you've got lots of stairs at your home, or this issue of isolation, that you are really very isolated. And if you can no longer drive, can't get out, that this is really not going to be a conducive place for you to live. Now is the time to just start thinking about what a next step would look like. What would be acceptable to you? A community, to be able to move to a continuing care community, something like Newbury Court and Concord, or one of the assisted livings. Is that something that would ever interest you? Getting your name on the list for senior housing, if that's appropriate and something that you want to consider, because as you know, that takes time to get your name to the top of that list. But using this time now to find out what's available is critical. Use this time to find out what a next step would look like. You don't want to be in the middle of a crisis and then be making decisions about what next steps should be, because you're going to be very limited and you're not going to have the full breadth of your own resources to understand what that would look like for you. So take the time now, find out what's out there for you. As a caregiver, take care of yourself. Make sure you're making time to take care of your own needs, to get a breather now and then, take care of your physical health and your mental health, because you will be no good to the person that you are providing care for if you go down. And trust me, caregiving takes its toll, and you will begin to feel it if you already haven't. So reach out, ask for help, find out what your resources are. And with respect to this whole legal discussion that we've had, if you have these caregiving, or excuse me, these legal documents in place, these decision-making documents, excellent. If you don't have them in place, find out whether you can still get them in place. So what is the competency level of your loved one? Where are they at? Can they still execute legal documents? Because if they can, now is the window of time to get it in place. If that time has already passed, and you need to move forward with guardianship or conservatorship, as daunting as it may be, you still want to look to get those proceedings started so that you have the authority to make decisions if and when you need to. And then utilize this time to really understand what resources are out there for you to give you full support as a caregiver, which is one of the most difficult jobs that there are. So I don't know if people have some, we can open it up to some questions or comments that people may have.
Yes, excellent. Thank you so much. We do have a couple of good questions here. The first one is, would your slideshow be available for us to refer to later?
Absolutely. We will make sure that Linda has a copy of that slideshow.
Okay, great. And then I will send it to the church. The church will send out, because they have all of your addresses.
Excellent.
And we will see that you do get that. So good question. It's a wonderful, valuable resource, isn't it? Another question was, what were the two community Medicaid programs that you earlier mentioned? Were the EATE and PACE? They weren't sure of the
So
acronym.
there are multiple ones. There's just two that I commented on today. One is called the Frail Elder Waiver Program, or FEW program. And the other one I mentioned is the PACE program, PACE. And both of those are Medicaid-based programs, or Mass Health.
We encountered a very interesting question. What recourse does a family, friend, or caregiver find when the level of care for the person that they care for is in a long-term care facility is not, as we say, advertised, such as in the brochures or as the staff choose to portray, and that the person feels that they're getting somewhat substandard care? What
Right.
recourse would there be?
So there's a couple of things I would recommend. So first of all, one of the things to remember is that it should be a collaborative effort. The staff, the facility should be willing to work with you as the family member to meet the needs of your loved one. I mean, that should be the primary goal. So I always begin with that kind of attitude when I'm working with a facility is, look, what do we need to do to make this better? Let's have a family meeting. This is something where you sit down, you have a case conference. What's working, what's not working, what's the plan of care, and how can we address these issues? Now, in a perfect world, the facility would absolutely be open to that. This is something that they, by regulation, by the way, should be providing at least quarterly, is a family conference, a quarterly care plan update. Now, in actuality, oftentimes these things don't happen, but begin with trying to approach it as a collaborative that we're trying to make this work together. The next thing is, if it's not working, the best thing I always say for anyone who has a loved one in a nursing home is it is about advocacy. It is about being in there on a regular basis. It's about advocating without always having to be adversarial. There are ways to do that. You don't want to make this where you're now butting heads with them constantly, but you have a right to say, I'm worried about this, I'm worried about that. As with the rest of the world, although this is a horrible excuse, most of our nursing homes now are extremely short-handed. So also take a look at what you're asking about, what you're worried about, and prioritize and make sure that what you're really wanting to discuss are things that are critical to the well-being and quality of life for your loved one. Okay, so take a look at what your concerns are and kind of prioritize what they are. If worse comes to worse and none of this is working, there's a couple of recourses that you have. One, every nursing home has an ombudsman. So Massachusetts has an ombudsman program. Certainly reach out to the ombudsman with what your concerns are. As with the rest of the world, though, they're slow to react. They also don't have the staff, etc. You always go a legal route, but I always recommend once you're going a legal route, you really have to look at, is this the right place for this person? Now, you can move somebody, just because you're in one nursing home doesn't mean you have to stay in that nursing home, although there are complications that you have to be aware of when you move somebody. One is finding another nursing home that is willing to take the individual. And that goes back to my thinking about the resources ahead of time. If you can think about a skilled nursing facility that if it were necessary that you would be comfortable with your loved one being at. That means going to visit them. It means going to check them out ahead of time if you can. But sometimes even when we do that and we get the person in the place, it's very different than what you had anticipated or thought it was going to be. But moving somebody is always an option. Legally, facilities are not supposed to discriminate against somebody based on their payer source. Meaning that they're not supposed to take those who have private pay money over those who are on Medicaid. In reality, that can be an issue. Suddenly doors aren't open as quickly. Suddenly there isn't a bed available when it's Medicaid oftentimes. So you need to be aware of that. But you can move somebody. But there can be complications with moving someone too, particularly for your loved one, who may have taken some time to get adjusted to this new place, particularly with dementia. Every time we move them and they're in a new environment, it can wreak havoc and it can cause them to quickly decompensate. So you need to be aware of that before you move somebody. That is a very traumatic thing for someone to go through and to have to now get acclimated to a new place. So I always would begin with your concerns, bringing them up the chain of command as you need to, bring in the social work department, the Department of Nursing, and the executive director's office as needed. There should be a plan of care in place for your loved one, and that plan of care should be reviewed at least quarterly. And if it's not, bring it to their attention. Participate in, and if they need to be more frequent to be able to address a particular issue that you may have, you want to see it built into the plan of care, and you want to ask them, how are they going to address this? Does that help at all to understand some steps that you might be able to take?
Yes, thank you.
Good.
We have another question. Have you encountered areas or circumstances where the guardian and/or conservator is misappropriating funds or is abusive in some way to the client? What recourse would they have?
Absolutely. So we see it not only with guardians and conservators, but we see it with powers of attorney and healthcare proxies too. So I'll give some examples. Healthcare proxy, denying other family members access, for not good reason. Now, there can be good reasons sometimes, but you have, as a healthcare proxy, as anybody, you always need to be careful about who you're denying access to and how you're controlling a situation. Remember, you're supposed to be stepping into the shoes of this individual, not imposing your own wishes on what's happening here. But that's an area where we see. Powers of attorney, they're very broad financial, someone absconding with money, taking resources, not providing appropriate, accounting for what they're doing. Now, with a power of attorney, it can be a little bit more difficult to force the attorney, in fact, to account for what they're doing. And you oftentimes end up having to bring this into the courts to make it happen. But there are always proceedings to remove someone in these positions, whether it be a healthcare proxy, power of attorney, guardian, or conservator. The guardian and conservator can be a little bit more, they're already in the courts. Remember, these are court proceedings when we're talking about guardianships and conservatorships. So there's already an entree to the courts. They are supposed to give annual accountings for what they're doing. The guardian needs to give an annual care plan as to what they're anticipating are going to be the needs of this person, what's happened in the past year, and what they anticipate for the next year. And the conservator is supposed to be filing an annual accounting for how they've handled the money in the previous year. All of those are filed with the court, and if you believe there's been some kind of misappropriation, then there are ways to be able to bring that to the court's attention. One of the issues, though, with the courts is you have to be seen as an appropriate interested party. You have to have standing with the court. So if you're just, not just, but you're a friend of the individual and you believe these things are happening, you may not have the appropriate standing to be able to object to something that has been filed with the courts. So through Minuteman Senior Services, through the Commonwealth of Massachusetts, we do have what we call protective services. You can make a call. You can make it anonymously to protective services when you have concerns, particularly about whether it's financial or about care issues for somebody. Again, like everything else, they can be slow to react. They are very behind in terms of caseload and they don't have the people to do it, but there is that in place to try to bring an action. If this is a family member who's acting in this position and there's any way to begin to have conversations with the person, that's always the way to start. Sometimes it's an education thing. And I often tell, like when I'm working with somebody who's acting, let's say, as the power of attorney for another person, I always say to them, look, if you've got siblings or other people who are kind of involved in this person's life, you should be an open book about what you're doing. This is something where you say, here's what's happening. Now, that doesn't mean you're asking for permission, because you're the decision maker. You get to make the decisions. You shouldn't have to be asking permission for what you're doing, but you share it with the appropriate people so that you don't have these questions and issues arise about, wait a minute, well, how is this person managing the money? Why are they doing things? Why are they, handling it this way, not that way? You're not asking for permission, but you're saying, I'm willing to share with you what's happening here. That can be a way sometimes to help alleviate some of those concerns. But there are ways to be able to bring concerns to the surface. One of the things that you have to understand, though, is that you may not be someone who has standing to bring that if it is already in the courts, or to bring something to the courts. And using something like protective services, if you're very concerned with somebody and what's happening, getting them involved to have them do an investigation is another way of being able to try to get at what's going on.
Absolutely. I have another question, and everyone, please feel free to add something in the chat box of any of your thoughts. Another question, Kathleen, especially since you are an advisor to many of the local hospitals, you've seen a lot, and you've probably had staff, physicians, whomever approach you and say, oh, what if? How do you approach when a hospital or a long-term care facility has a patient who has no family or friends known, and they need to have someone act as a financial overseer or as an advocate of sorts for them? They never bothered to do any legal estate planning at all. They just are here. Sometimes I found this as a nurse. Certainly I found this with the homeless.
Right. So the first thing we always ask is, what level of competence does the person have? Because again, remember, we always presume the person is competent to be participating in all of this. And we want to see, can they go ahead and put in place their own decision makers? Is there anyone that they can identify who they want to name? Now, if someone is competent and they otherwise choose not to do this, and not to do the things that we think are appropriate for them, we have to honor that person's level of competence. I always say, if someone is competent and capable of making their own decisions, they get to even make bad decisions for themselves. And we have to honor those bad decisions. So that's the first thing we look at, is what head and participate in putting these documents together, and do they have people in their life who they can name in these important positions? If not, so if the person does not have competence, and we now need to go, this is where hospitals oftentimes actually begin the court proceedings. They will actually say, we've got to get somebody in place who can be named to make decisions. And these are the circumstances in which the court will often appoint somebody, a professional, such as myself, ends up being appointed to be in the position of decision making. And then we're in a whole different realm trying to figure out what is appropriate for this person, because we oftentimes don't have that framework to make the decisions. Right.
We have another question. Can you have a power of attorney and a fiduciary who will handle the money?
Yes. So power of attorney itself is naming somebody who's going to manage the money for you. There are some other documents that may name people. One is if you have a trust of some type, then a successor trustee may be in a position of managing money. Depending on how you have bank accounts held. So if you have any of your financial accounts jointly held with another individual, remember they have full access to those assets, and hopefully will do what's right in helping you to pay bills and that kind of thing. But they do have, if they're a joint owner, 100% full access to that account. So you have to be aware of that. But absolutely, the power of attorney is really the document that we utilize to name somebody who then can step forward and manage your financial affairs for you, paying bills, managing your bank accounts, making investments, all of those kinds of things.
Are there any other questions? These have been great. Any thoughts? Or is it going to be one of those things where, oh, afterwards, I should have asked, right?
And I'm always happy to have you reach out even afterward if you have a question that comes up. Just remind me that where you were from.
Right. I've asked certain individuals, I've sent you a private note for you to give me your email address, because some of you, we did not have from the church one when you registered directly with the church. If you don't care to give it to me now, that's fine, no worries. Just contact the church where you spoke with them originally when you registered, and they will put you on the list so that you can be receiving these slides that Kathleen has provided for us, okay? So it'll probably be a little easier if you just notified the church and said, hey, I'd like to have some of those slides. They were just super and very informative. Are there any other questions? Any other thoughts, concerns? Nicolette, you'll need to unmute, Nicolette.
Yeah, I do better if I can ask the question than type it in. The program will be over. Kathleen, you mentioned that you're part of a Dementia Friends group at the beginning of the program. And you mentioned that there used to be a restaurant, namely the Rusty Scupper way back when, that had lunches that were especially good and dementia friendly. And we have this midweek dementia friendly worship service. And sometimes the thought is, wouldn't it be nice for people to go out to lunch? And so it would be nice to know if there are any other places you know of that offer this hospitality.
So Nicolette, the only one I knew of was, it used to be called the Red Raven. It just came back to me, the Red Raven, and they had a specific time each week that they did a lunch that was what they called dementia friendly, in the sense that the staff was all prepared. You know, one of the places that I would contact is the Alzheimer's Association. I believe that they do have a list of organizations that do specifically have training for dementia related issues. And, you know, it's one of these things that if we could get more companies, I mean, I always say to banks, when I'm talking with bankers, I always remind them, they seem to be one of the first places that these issues begin to show up. They begin to see when someone, particularly the smaller banks, they start to see when someone's not handling their finances well, maybe bouncing checks, maybe not, you know, coming in very frequently to find out how much money's there, worries about someone taking money out. All of those things oftentimes show up at that banking level. And to have their staffs trained to really begin to recognize, I think could be so wonderful, as well as so many other businesses like a restaurant that would have staff who could have a little bit more patience and understanding when they're dealing with a patron who may be having dementia issues. And again, the caregivers need a chance to get out, to be able to have gone and had a lunch with a staff where you didn't have to be worried about what was happening and not having to be explaining. Oh, it's a wonderful gift. It's a wonderful.
It is. Thank you.
We have another question. Do you know if the $2,000 to qualify for Medicaid is the same outside of Massachusetts?
I believe that is a consistent value in all states. That's part of the federal oversight that they set it at a $2,000 limit. What we see different from state to state are the rules around income is one big one. What income levels are considered for what programs, how the 5-year look back works. 5 years is consistent for all state, but some states do have other bits of flexibility in terms of what you can transfer and when. So it really, I can only speak to what's happening in Massachusetts. It's amazing how every state has its own nuances in terms of these programs.
Are there any other questions or comments?
Virginia has one.
Um,
Virginia, you're on mute.
Unmute, Ginny. It's to the lower left.
There
Mute
we
button.
go. I'm sorry. I'm under the money management program with Minuteman Services. And it's the gentlemen that are helping me with this are excellent. And I'm just wondering, I don't have family that I can turn to. I don't have, you know, I don't have family that I can turn to and trust. Can someone in the money management program, because they really are learning my finances, can they become my
The
not my,
power of attorney.
yes, yes.
So, first of all, wonderful for you. That's a great program and good for you for seeking out that resource. That's fantastic. I do think that they don't allow their money managers to also act as power of attorney. I think the worry from Minuteman Senior Services standpoint is that there's too much liability. Because once someone becomes power of attorney, then there's, you know, concerns about how they're handling the money and that kind of thing. And the money management part, they're doing things like balancing your checkbook and all of that, but not actually have authority to write out your checks. Now, there are professionals who will act as power of attorney. Some attorneys will do it. There are some other professionals out there. There are some financial planners. There are some CPA groups that have bookkeeping services that will act in that capacity. But you do need to seek them out. You do need to ask the different professionals if they're willing to be a power of attorney.
Okay, what about having, I'm really concerned about finances now, and with everything going up. What about having a lawyer? But then I'm also concerned about the cost. Having a lawyer, that's what I was thinking of, having as a lawyer to be my power of attorney.
Right. And so that is one of the issues. Yes, many lawyers will act in that capacity as power of attorney, but you're right, Jenny, they do charge for their time, and typically that's not inexpensive. So it's a little bit of a balancing act. Now, you could name someone as your power of attorney. Let's say you did decide to use an attorney. Remember, they don't need to necessarily step forward now. You continue to use your money managers the way you are. It is really a fallback in case there is a situation in which you can no longer make these kinds of decisions for yourself.
Right.
Right.
I understand that.
Right.
Okay,
So
thank you.
that's something to consider.
Okay, thank you.
Are there any other questions? Wow.
I think Duncan and Connie.
Hi. On the power of attorney, is there wording in there about liability and trust and things like that for when you do hire a power of attorney, or if it's a family member, as to what their obligations are in using the money? I mean, is there a checklist where you can say you can do this, but you can't do that, or you know, and then how would you handle that if they do embezzle? You know, I mean, is there something written in there that says, okay, you've done this, now we can go after you legally or whatever?
So very good question. So a couple of things. You can always limit the authority that's in a power of attorney. The issue is, though, that if you limit that authority, we don't know what your power of attorney, what we call your attorney in fact, would be facing should they have to step into your shoes. So you have to be careful that if you limit, that might cause a problem. For instance, my father-in-law, my husband and his siblings, one of the siblings is estranged from the family. But my father-in-law wanted to make sure that all of the siblings still benefited from the estate. Now, the power of attorney can give the ability to change someone's estate plan. For instance, change the beneficiaries on things like retirement plans or life insurance. And there can be very good reasons to allow your power of attorney to do that. There's planning reasons. But in this case, he didn't want that authority, and he knew he was taking it out, and he knew that would then be limiting the ability of the power of attorney to do it. But he did not want the power of attorney to be able to change things like the designation of beneficiaries on a retirement plan. So you can do that. Now, the person who's acting as your power of attorney by law has a fiduciary responsibility to you. That means that they are supposed to be acting in your best interest, not their own. Now, we can make it so that a power of attorney can't benefit themselves. And if I were acting as someone's power of attorney, as Ginny had suggested, like let's say I as an attorney was acting as your power of attorney, we would want to take out the clause that says, oh, by the way, my fiduciary can benefit themselves, because I shouldn't be benefiting other than my legal charges for what I'm doing. But if your child was acting as your power of attorney and it was appropriate during your life, you couldn't manage your own affairs, let's say, but it was appropriate for them to give a gift to all of your children. Then we would want your attorney, in fact, to be able to also benefit from that because they're one of your children. Does that make sense?
So that would have to be spelled out, though.
So we have to, right, and you can do that in the document, but the more you tailor the document, the more you have to remember that that may impede a decision in the future. But you do want to think about those things. And then if someone does act inappropriately, by all means, there's always the ability to be able to go after them criminally and civilly for what they've done. The problem is that oftentimes once they've taken the money, you may have problems getting it back because most times they don't have it for some reason. So it's a little bit of a frightening story, but I do have a situation that I'm currently involved in which I am the conservator. So I was appointed by the courts. This was involving a married couple, both who were starting to have issues in terms of their cognitive ability. They only had one child. They named that one child as their power of attorney. I wasn't involved in this beforehand, not that I would have caught this at all before, but I wasn't involved before. Unfortunately, the son absconded with 90% of their estate. He took it. And, both of these people are in their 90s. Had he just held off a little bit, he was going to get it all anyway, but he got greedy and he took it. And that what happened was this was found out in terms of they had caregivers involved who started to see that there were issues with the son taking money. They brought it to Protective Services, and Protective Services brought the court proceeding to remove him as power of attorney and to appoint a third party, myself, as the conservator. Now we've gone ahead and done legal proceedings against him, but he's left the country. And it's very difficult to be able to get him because he's now in a country in which there's no reciprocity in terms of, legal representation. So we've got an issue. We stopped him. We were able to get him out. He's no longer the power of attorney, but the old adage that you can't get blood from a stone, that's what the issue is.
Oh. Well,
Well, I got one more. We're in a situation where we're trustees for our daughter. And if we were to do a power of attorney, would they be able to take over the trusteeship for our daughter at the same time, or is that a separate document?
So if you're trustees for your daughter, then there most likely is a trust document in place
Yeah.
that set up that trust. That trust document should outline who gets to step into your shoes if you can't handle things anymore. Now, it may allow the power of attorney to do that, but it's going to be the trust document that controls how that gets managed. So it may name a successor trustee to you. And if you don't have a successor trustee named in that document, someone who'd be able to step into your shoes if needed, you might want to consider finding out how you can name a successor trustee so that you've got control over who would be that person should something happen to the two of you and you can't manage it anymore for her. But that document should talk about how that gets done.
Right. It does. Yeah.
okay.
Okay.
Well, thank you. We're unfortunately running out of time right now, but you can always contact her. Under the best of circumstances, this can be a challenging time for everyone, including the caregiver, the family, and for the person who will be facing such a difficult time in their life, right? So thank you so much, Kathleen, for providing us with such valuable information on such an important topic. Your insight into the legal considerations was very helpful, and I suspect it will open many doors for future discussions from the participants in this webinar. I've included in the chat box the contact info for Kathleen, and feel free to reach out to her or anyone in her legal practice for guidance. So, on behalf of the Call to Care Ministry team here at UCC Boxborough, I'd like to thank all of you for joining us this morning and hope that you now have a better understanding of the myriad of legal concerns that may arise when caring for a person with such a life-altering circumstance. So thank you again, everyone, and have a great day.
Thank you, everyone. Take good care. Linda, thank you so much.
Thank you so much. Wonderful.
Bye now.
Bye-bye.
Bye-bye now, everyone. Thank you.
Bye.
Good to see everyone.
Get it.
Thank you.
Thank you. Bye-bye now.